because today we're really talking about, what is the role of family law lawyers? What do you
Yeah.
expect? And thank you for everyone joining us. This week, we're talking about the role of family law lawyers. And just a reminder, we have disabled the chat function. So if you do have any questions, please submit them through that Q&A box. We always welcome questions, comments, feedback. And just as a general reminder, the purpose of this series is to discuss general information on separation, divorce, and other family law related matters. So any information provided here should not be construed as legal advice. If you do have questions regarding your specific matter, please call our office or a lawyer in your area to get a consultation for tailored legal advice specific to your situation. So I'll just start off with some introductions. We have Shanza on our screen. She's a recent law graduate from Osgoode Hall Law School and is an articling student at the firm with plans to be called to the bar in Ontario in June of 2024, which is very rapidly approaching. So focused on launching her legal career in family law, Shanza is dedicated to providing empathetic and proficient legal support for those navigating family-related complexities, and her valuable experience stems from active participation in legal clinics, mooting competitions, prior work as a legal assistant, and of course, her time articling with our firm. So as she embarks on her legal journey, Shanza is poised to contribute to the firm's commitment to excellence in family law, leveraging her diverse background and unwavering dedication. We also have Joseph, another articling student at our firm, who's been busy with the trial. So he is also set to be called to the bar in Ontario in June of 2024. He's a recent graduate of the Ted Rogers School of Management at Toronto Metropolitan University, formerly Ryerson, and Queen's University Faculty of Law. As he enters into the next phase of his legal career, Joseph is committed to positively influencing the lives of those facing difficult family situations. And as always, he's a true through and through Leafs supporter, loves hockey in his spare time and comedy movies.
Great game yesterday. Sorry.
Yeah, you know what? I thought Sidney Crosby was single-handedly going to win that game for him. He was in the zone, but the Leafs pulled it off.
And following our little sports detour that it's sort of become tradition now. We also have Russell. Russell is the founder and senior partner at Russell Alexander Collaborative Family Lawyers. With over 25 years of experience, he uses his knowledge and expertise to serve his clients in all aspects of family law and helps them cope with difficulties of separation and divorce. Russell has written 4 books and is a fully trained collaborative practice lawyer. He speaks at conferences on collaborative practice, marketing, technology in the law. His most recent book was AI in the legal profession. So if you ever want to check out his work, we highly recommend it. And then there's me. So I have been with the firm since 2018. I was called to the bar of Ontario in 2022 and am now an associate lawyer at the firm. I completed my undergraduate degree at Queen's University and obtained my law degree from the University of Liverpool in 2020, graduating with first-class honors. I'm also trained as a collaborative practice lawyer, as well, all 4 of us are, and I'm committed to assisting clients through what is traditionally a difficult time by approaching matters with empathy, integrity, and compassion. So with all of us being introduced, we'll just jump right in.
Let's get at it, right?
Let's get at it. So the first sort of topic that we want to talk about is, when do you hire a family lawyer? When's the right time? What's the right reason? And it's really tailored to every individual person. I've had clients come to me before even letting their spouse know that they wanted to separate, because sometimes having a lawyer in your corner at the outset can either aid in letting your spouse know that you want to separate, or it just helps a client or someone contemplating separation understand what their rights and obligations may be, or if they aren't ready to separate, if it's not worth that pursuit of a separation, and what they're dealing with in their marriage or in their relationship is something that they would rather work on or have another stab at. So identifying the right time and the reasons, it's, like I said, very personal. But the reasons to hire a family law lawyer is exactly that, to know your rights, to know your obligations, and to walk you through what your options are. You know, we've discussed various different ways of approaching a family law matter, whether it's litigation, collaborative practice, negotiating a separation agreement, going to mediation, going to arbitration. So having a lawyer in your corner from an earlier point will help you navigate what the best roadmap is for you. Because, you know, if your matter is less complex or you and your spouse are on amicable terms, jumping right to litigation might not be appropriate for you if the two of you could work amicably together to negotiate a separation agreement or a parenting plan. Um, Another reason to retain a lawyer is for the support when you're going through the process. So, especially if it's litigation, you know, a lawyer will help advise you on timelines, on, you know, court decorum, on what materials you need to file, and help get you to those through those stepping stones until you reach a final resolution. So those are just some things to consider, but it really boils down to, are you ready? And who or what lawyer would be right for you? And Joe, what are some things that people
Can I
make?
just, can I
Sure.
just jump in? Because, you know, I think just want to emphasize something Stephanie said. Getting in early to see a lawyer, like I think you were talking, Steph, you do a lot of pre-separation legal advice. You know, that's probably the best thing you could do, right? You want to go into this with a plan. If you wait until you have the blow up or somebody said I'm gone, or you know, if you wait until that decision's made, now you're playing catch up. So a lot of the times when I would meet with clients, especially pre-pandemic, a lot of this discussion is, should I stay or should I go? They didn't know if they should leave this relationship. You know, that's not something really a lawyer can tell you what to do. That's sort of one of the personal decisions you need to pull the trigger on. And a social worker or a counselor can help you with that decision. What we can do is say, if you do go, here are your rights and obligations. This is the roadmap we would lay out for you, so you know what your options are. The other thing you may want to consider is preserving evidence. And I get this a lot. You know, there's that shoebox full of cash under the bed. You'd be surprised how many people have cash or in a safe, right? Or in one case, it was collectibles, you know, sports memorabilia and special baseball cards, or it could be jewelry. It could be gold. Surprisingly, people are stocking up on gold and silver bars right now. Costco's selling them online. So you want to get a record of this cash or these assets before they're gone, because if you separate, the safe's emptied out now, it's he said, she said. And if you have an inventory and maybe some photographs, this evidence you can present to the court. The other thing I want to add, Steph, if it's okay, you want to develop a safety plan.
Yeah.
So if you're a victim of domestic violence, you want to make sure that you have an exit plan that's going to keep you in a safe place with your children if necessary. There's a whole bunch of resources that you can access if you're a victim of domestic violence, or maybe your partner has been charged with assaulting you, or there could be historical assaults. Whatever the circumstance you find yourself in, you're going to want to develop a safety plan. Unfortunately, the stats for violence in Ontario and Canada, you're more likely to be assaulted by a partner than a stranger. And statistically, it's a very high risk time for people going through separation and divorce. So you want to be mindful of it. And on the other side of that, if somebody's making false allegations of domestic abuse, you're going to want to make sure maybe you get a criminal lawyer. You put some protections in place to make sure that you're not charged criminally if you're worried about that. So finally, and I hope I'm not touching upon other people's topics, but you want to talk about goals and interests and develop a strategy. So we're going to get that into a little bit later, but I really like that idea, Steph, of planning early, getting ahead of this. Even if you're not going to separate, at least, you're prepared and you know what your options are. Joseph or Shanza, do you want to add to that before we move into Joseph's topic?
I just wanted to say that sometimes we have people like come to the initial consultations, and sometimes their concerns are, oh, my spouse has been talking to a lawyer for some time now, and I'm just hiring when I have no idea like what they know or what they've been working on. They're concerned that they might be depleting assets. So I'm all about what Russ said. Start early. So you walk into it knowing what you're doing and what your rights are and what your spouse's rights are. And so you kind of have a more basic idea of what you're walking into. So you're not concerned that, oh, like my spouse know more than me or they've been doing things behind my back. So you have your lawyer kind of there to protect you and protect your rights.
Yeah.
Yeah, 100%. And that sort of shifts into, okay, you're at the point where you're ready to speak to a lawyer, you're ready to hire a lawyer. Well, what should you be looking for in a lawyer? And Joe, do you want to jump in?
Yeah, thanks. So firstly, sometimes it's not always evident, but you want to look for a lawyer with experience in family law. That's really, really key. There's so many different streams and practices of law that lawyers practice in Ontario. But if you are getting a separation, you have children, you have questions about how am I going to be supported financially? Who is going to be making decisions for the kids? You are not going to go to a real estate lawyer. You're not going to go to a criminal lawyer. You're going to go to a family lawyer. So that's really, really important when you're doing your preliminary research, is that you are looking for a lawyer with experience in family law. Second, a big thing is reputation. So it's also really important to consider the lawyer's reputation, both within the legal community and among past clients. That's really easy to do through client reviews and testimonials. So that can be checking online reviews, or even asking for testimonials from previous clients to gauge, their satisfaction, their experience with the lawyers. You can also go to the LSO lawyer lookup page. There you'll see if there's lawyers with restrictions or limitations on their practice, if they've had any prior issues with the Law Society. So that's also a really good resource to look for as well. With respects to qualities, you want to look for a lawyer with strong communication skills. So a good family lawyer should be both an effective communicator. That means in terms of being a good active listener, and also being able to articulate themselves in a way that is easy to be understood by the client. As well, you want a lawyer who's empathetic. It's important to look for a lawyer who shows empathy and understanding towards your situation. And I know we talked about this for a few weeks now, but really important that we don't confuse empathy with not being realistic about your matter. You also want a lawyer who's realistic about the situation, about what maybe the future outcome will be with you. You don't want to be guided or misled in the wrong direction. And finally, or I shouldn't say finally, but availability is also really important. You always want to ensure that the lawyer can dedicate adequate time and attention to your matter, as well as cost transparency. So the lawyer should be upfront about their fee structure and any additional costs involved, such as additional court costs, like for filing fees, any disbursements that there may be, whether that be through serving your materials on the other side, any other like photocopying of any sorts, as well as expert fees. So all of that should play a crucial role in choosing the right lawyer for you.
Yeah, those are great tips. The reviews are important, right? Most people buying stuff on Amazon look at the reviews first. And there's going to be outliers. So some lawyers, maybe they represented a spouse and the other spouse left them a bad review. So read the reviews, right? Read how the lawyer responds to those reviews. Do you expect a negative review once in a while? It's the nature of, unfortunately, what we do. We're dealing with people who are unhappy sometimes, and sometimes they lash out at their lawyer, rightly or wrongly. But it's not just online reviews. Talk to friends and family, right? Get referrals from people that you know, people who have been through the process who may have already used a divorce lawyer. Those are very valuable as well. And I like what you said, Joe, you know, it's sort of a gut check, right? Can I communicate with this person? You know, is there that relationship where we can have frank discussions and communicate effectively? That's probably the most important aspect of your relationship with your lawyer.
Yeah, and I think just to sort of bounce off that, Joe, your point about empathy is important, yes, but far too often we may see lawyers that take empathy and confuse it with you know, being a sound piece or sort of a continuation of the stress or the anger or the hurt of their clients. And although it's, yes, I imagine very helpful to have a lawyer to empathizes with you and sort of you feel like they're in your corner in that regard, but you also want to remember that there's more to the legal process than getting your point across. You have to think big picture and think about what is realistic, what is a good claim, what is, you know, worth pursuing. You know, it could be more costly if a lawyer is just constantly just saying exactly what you want to say and not having those tough conversations about realistic expectations. So
And those are hard lawyers to deal with, right? These lawyers that emote their client's behavior. So what I'm saying is they're taking on their cause, their fight like it's their own. And they're not providing their client with dispassionate legal advice, right? So, you know, I sometimes have to remind the lawyer, you know, you're an advocate here. This isn't your life. You're not, you know, you need to provide some practical advice to your client. And they get caught up in the fog of war and trials. Joseph's in the middle of a trial. And so the lawyers that emote their client's behavior, although it may be reassuring for the client to have that mirroring effect where they're simply saying back to them what they want to hear, they may be disappointed with the outcome because the judge may not necessarily agree, and it may turn out to be an expensive process. So that was a really good tip, Steph.
thanks. And usually the first step in any sort of retaining process or speaking to a lawyer, the first step will be that initial consultation. That's where you have an opportunity to speak to the lawyer, figure out if it's a good fit. But how can you prepare for that? Shanza, what are some tips or you know, things that people can expect when they book that initial consultation?
Thanks, Steph. So, like you said, the initial consultation is your first meeting with the lawyer. This is the first time you're talking to them, so you want to take this meeting to tell them about your relationship, discuss your issues, things that are important to you, your needs and preferences in terms of why you're contacting the lawyer, what your expectations are, what you're looking for. The lawyer will ask you questions. They want to know all the basic information that they need to be able to answer your questions and get a full understanding of your issues. They'll probably give you an overview of the law and how it applies in your situation and what you're trying to seek. It could be parenting time, child support, property, whatever it is that you're seeking. They'll probably talk to you about that, give you a basic understanding of the law to the specific issue. And once the lawyer has more information and they kind of know what's going on, they will discuss like any potential roadmap for moving forward. So you kind of have a plan of where you're going and what to expect along the way. Like, you know, during the first call, the lawyer might find out there's timelines or limitations. So we don't miss those. That's something that can come up. And stuff you hit on preparing. So in terms of preparing, I would say the lawyer does need like basic information in order to guide you better. So you do want to come prepared with dates and information like the date you married, the date you separated, full legal names of your spouses and kids, date of births. The more you know, the better. Your income, your spouse's income. If you have been served with any documents, you want to provide those to the lawyer. If you signed a cohabitation agreement or if you signed a separation agreement, you want to bring those in. file your income tax, right? You'll need that, not necessarily for the ICs, but your lawyer will ask for them, and you do need to provide financial disclosure. At our firm, we do get the clients to kind of fill out an intake forms to get all this information, so the lawyer has it prior to the meeting. But yeah, you want to write down any questions that you want to ask to make sure that you can get to all of them during the meeting. And yeah, that's a little overview of what you can do for your.
An IC is an initial consultation. That's what some lawyers will call your first meeting with the law firm. But Shanza, those are great tips. What we do, we have a lot of form fills. So your average, let's just say you're going to meet your lawyer. The traditional meeting, we spend 30 to 45 minutes getting background information, relationship dates, income, ages of children, assets, all the bits and pieces that went into your marriage. Now we get that information in advance, like Shanza said. So you'll be able to get that information into your lawyer. Maybe you have to look for it, right? Maybe you don't know what the income is or what the relationship dates were. And so by sending that into us, for example, if you're going to come meet with us in advance, what it gives the lawyer a chance to do is to look at your matter before you come in and start thinking about how we can best help you and your family. So like, again, Shanza said, maybe you have a separation agreement, or maybe there's a court order that exists. I would like to see that before you come in, because I can't give you legal advice on a document I haven't read yet. And oftentimes people are nervous, they forget their documents. So by sending that into me in advance, I can start thinking about, okay, is there a material change? What are the dispute resolution provisions? What are, maybe there's a clause that you have to go to mediation first. So your lawyer can start thinking about these things even before you come in. And that way we're not going to have to reschedule your meeting because we're missing some documents or some information and have you come back for another meeting, which could be difficult if you have work or childcare responsibilities, or maybe even just logistically getting into the office for a second time. So those are great tips, Shanza. So the more information you can organize and prepare and give to your lawyer, some lawyers don't want it, right, until they're retained. We want to try to get as much information up front so we can give you the best meeting when you come to see us. And there's no pressure to retain us, but if you do want to retain us, it's great. But if not, at least we can give you a roadmap and some advice in terms of what we think you should be doing and how you can protect your rights and interests.
Yeah, 100%. And I think that from a lawyer's perspective and a client's perspective, it makes that first conversation a lot more efficient, a lot smoother. And then you really have an opportunity to understand what this solicitor-client relationship might look like, because it is a relationship at the end of the day. If you don't feel like you can be honest and transparent to your lawyer, maybe that's not the best fit. Like every relationship, it takes two to tango, right? So it's always important to keep that in mind and to see if your personalities click as well.
And we're really good at keeping secrets, right? So what you tell us, it's a privilege. We can't repeat it. But if you don't tell us, the bad stuff, or what you may be embarrassed to tell us, or whatever you're holding back, tell your lawyer so they can give you advice and help you prepare to deal with that issue, because it's likely going to come up in your case later on by your spouse or somebody else. So have us explain it at the front end, and we're here to help. So we're not passing judgment on you. We're here to help you through a difficult situation.
Yeah, and I'm just going to sort of shift things around, because that really ties into what your solicitor client or lawyer client relationship will look like. There's communication components. Russ, you touched on confidentiality. There needs to be trust. So I know I'm shifting things a bit here, but Shanza, do you mind just jumping in and sharing as well?
Yeah, I think like you and Russ, you both kind of hit on like some of the major things that
we didn't steal your thunder, did we?
You did, but that's okay. I'll expand on it. So
I just gonna be quiet until it's my turn. I keep doing that.
I was gonna mute you, Russ, but no. But yeah, lawyer-client relationship, I think I'll just say that it begins when a client kind of requests legal counsel or representation from a lawyer. And you can hire a lawyer on a more limited basis, or you can retain them as your counsel. Regardless of why you're hiring the lawyer or the extent of their services, this initiates a lawyer-client relationship. And like you both said, it imposes like certain rights and obligations on both parties. In family law specifically, we're dealing with very private matters. So it's all about like the lawyer-client relationship is all about trust and understanding. Family lawyers deal with deeply personal stuff, so it's crucial to build a strong connection with the clients. The client must be able to trust the lawyer. They should be able to confide in them. We don't pass judgments. Nobody's perfect. Like everyone makes mistakes. So like we're not sitting here, passing judgments on anybody. And on the flip side, the lawyer should be able to trust the client. Effective communication, empathy, a commitment to understanding the client's circumstances. All of this kind of affects your relationship with the lawyer. There is the solicitor-client privilege, which essentially ensures that all communication between the lawyer and the client, it stays confidential and private. And knowing that anything that you're discussing is going to stay between the two of us, it ensures that the client can speak openly and honestly, without fear that anything that you're saying could be disclosed to other parties or your spouse or someone else, or your kids. It covers it covers both written and verbal communications. Confidential is important, right? It builds trust, it provides ease, so you can be totally honest. And this privilege, it remains in place even after your case concludes and the lawyer-client relationship terminates. So, it's forever there. There are some exceptions to it sometimes. I won't get too much into it, but for example, if the lawyers can break confidentiality if you waive it, for example, or if there are concerns of death or serious bodily harm. So there are some exceptions available in those cases. But overall, when we talk about client-role relationship, it's about having a good working relationship with the lawyer where there is proper communication, you feel heard, you trust them with the information, you feel like they're competent to handle your case, there's no conflict of interest, they're able to provide you with sound legal advice, and just being truthful and open in terms of likely outcomes for the client. I know, Joe, you were talking about it earlier. Similarly, for the client, they want to be honest, they want to tell the entire story to the lawyer. Your lawyer doesn't want to be ambushed with any last minute information. Disclose everything, be patient, be honest about your ability to pay, follow your lawyer's advice. I know I just keep listing all these all these items, but I feel like the relationship itself, it encompasses so much, and everything kind of just comes in together and forms this relationship. And I say that sometimes people are, dealing with their legal, issues for, I don't know, 3 years, 4 years. So this can be a long relationship. So you do want a working relationship because, it can be a long time when you and your lawyer are, working on your legal issues. So just being comfortable and being confident with each other is, kind of speaks to the relationship. Okay, I'll stop talking.
Well, that was
I-
great. If you lie to your lawyer or mislead your lawyer, we're required to meet certain timelines for you. So if you're not producing the documents we need, your lawyer's gonna end the solicitor-client relationship, which is a fancy way of saying is your lawyer's gonna fire you. We're officers of the court. We have a duty to provide the court with truthful information. We find out that you've misled us and we've subsequently misled the court, that's going to affect our reputation. So that is essential.
I think it's also really important to highlight that there is a difference between the solicitor-client relationship and solicitor-client privilege. You know, as Russ said, the relationship can terminate, whether that be the client fires the lawyer fires the client. But privilege is something that's permanent, and it even survives the death of the client. So that confidence doesn't end when your case is done. It doesn't end 5 years from now or 5 years from when it concludes. It doesn't end even when you pass away. That privilege is permanent and it does not leave. So, you know, rest assured, the confidence is there, and it's really important to be truthful with your lawyer because your lawyer can't break that.
Yeah. And worst case scenario, you fire your lawyer files, they're still going to keep all your information private and in secret. So
100%.
that continues. That's a great point, Joseph.
Yeah, 100%. And, you know, sometimes a big component of the relationship, the solicitor-client relationship, is fees. You know, at the end of the day, it is a service as well. You are hiring your lawyer based upon a retainer agreement, based on a fee structure. So what are some examples or some possible, you know, tips for managing costs of a lawyer? Joseph, do you want to take this one?
Yeah, for sure. So sort of how you introduced it, there's the sort of the fee structure aspect as well as the managing the cost aspect. So that's sort of how I'm gonna speak to that. So with respects to lawyer fees, the fees that you pay to your lawyer are the most significant cost in your separation or in your family law matter. Lawyers in family law either charge via an hourly rate or a flat fee. Contingency fees are not allowed in family law. They're also not allowed in criminal law, but a contingency fee is, you would see it in personal injury, for example, where they take a percentage of the outcome. So, but in family law, we don't do that. We're not allowed to. The Law Society doesn't allow us to, and same thing with criminal law. And the lawyer fees itself are influenced by case complexity, as well as, you know, the longevity of your matter, as well as the lawyer's experience. So the more experience the lawyer has, most often, more typical, they would charge a higher hourly rate. Aside from aside from lawyer fees, there's also the court costs. So court costs involves paying court fees for example, processing a divorce application, as well as any other filing fees that may occur. And those would be like the additional costs. There's also what's called disbursements. So disbursements are out-of-pocket expenses that are paid by the lawyer. So for example, those can be courier fees, and any other administration fees like photocopying your documents, storage, etc. And those are also added throughout the retainer agreement. And then another type of fee you may expect in your matter is an expert fee. So sometimes your lawyer would recommend the hiring of experts. For example, doing a Section 30 assessment, and that would be if there's any issues regarding parenting. So that provides that's when a private investigator that's paid for by the parties do an assessment on the parenting issues. Or even through a financial analyst, whether that be a business valuator, any real estate lawyers that you hire, any other third-party experts, so sort of bring evidence to light in your matter. And that also adds to the overall cost. So those are sort of the big breakdowns of the fees that you would entail in your matter. With respects to managing costs, the law and going through your matter can definitely be pricey. So there's a couple things that we try to tell our clients to limit those and manage those costs as best as possible. The first being transparency and estimates. I sort of group that together. So as we mentioned earlier with the initial consultations, the initial consultation offers an overview of the legal process as well as some of the costs you may incur going through your matter. And it's also really important that the lawyer provides regular updates on ongoing costs. So that can be sending an invoice every week or every couple weeks. And that's just to keep the client informed on how costs through the trust fund are being spent. In terms of reducing legal costs, we spoke about it a few weeks ago, but an uncontested divorce does dramatically lower fees as well as court costs. But if you are not in that boat and you're not necessarily doing an uncontested divorce, but there are matters that are trivial between one another. Mediation or any other form of alternative dispute resolution, such as collaborative practice, are also very cost effective as opposed to going to litigation. Also, other tips that Steph, Shanza, and Russ both mentioned, it's really important to be organized. Always respond promptly to emails that you receive. And also, sometimes you can even take a proactive approach and handle tasks yourself rather than relying on the lawyer or the clerk to reduce billable hours for yourself. Also, another one that's not really spoken about much often is that every time you send an email to your lawyer, they have to open it, review it, read it, and provide a response. A lot of times you can send that same email to the law clerk for a fraction of the cost that you would be paying through your billable hours. So we have some of the greatest, I know I'm speaking for our firm, but we do have some of the greatest law clerks, in the country in terms of family law. And although a clerk cannot provide you legal advice, they can provide you pretty much with any other advice for your family law matter, and they are such a good resource. So oftentimes we recommend to clients, hey, listen, if it's not pertaining to a specific question of law or an issue that you may have relating to an issue of law, reach out to the law clerks. That's such a great way of saving money. And just sort of some final thoughts and recommendations. It's really, really important to budget realistically for your separation expenses. While we do try to give an estimate through the initial consultation, we don't know the other party. So we don't know how they're going to react to the matter as a whole. So it's really difficult for us to provide a concrete estimate or even just a rough estimate as well. So that's also really important for you to budget realistically in terms of that. You can also look for lawyers. Some do offer payment plans or a sliding scale fee, but that varies very differently between firms. And it's also really important for yourself to clarify any charges on your invoice. Ask questions. Lawyers we don't take offense. If you see something that you don't understand on your invoice, don't be afraid to ask a question. And also too, that people sometimes sort of don't necessarily, it doesn't alert them right away, but you can also see and check your availability. Sorry, not your availability, your eligibility for assistance from Legal Aid Ontario, utilizing Duty Counsel, all great resources that are at your fingertips.
Great tips. Note that tip about the email, maybe you've got a question you want to ask. Maybe hold off for a day or two, the answer might come in. Or ask your law clerk or your lawyer 10 questions in one email, and they can just, instead of going through 10 emails, they can go through one. And you're right, Joseph, mistakes happen. I've put my dockets in twice, not even noticed it, but the client pointed it out, so we gave them fee credit. We're human. Sometimes the entry is going to be doubled up, or it could be a software issue. The other thing about fees, sometimes your fees could be tax deductible. If you're seeking support or child support, you might get a bit of a tax break if you make the proper claim with the Canada Revenue Agency. So you want to be thinking about that as well. But great tips.
Yeah. And I think, a conversation that I have with every consultation, with every new client that comes through the door is, and I can only really speak for our firm, but we want to ensure that your retainer, your pot of trust funds can last as long as possible. So, when a clerical task needs to be done or an administrative task needs to be done, we want to ensure that the right person is doing that. You don't want to pay your lawyer's hourly rate to schedule a call or to do filing. We always want to make sure that the delegation is done so that your retainer can last as long as possible. And, when in doubt, look at your retainer agreement, right? A lot of questions that we get, can often be found in the retainer. That's going to be your holy grail as to what are my expectations as a lawyer, but what are your expectations as a client as well? How are my, how are billables going to be entered? Or is it 0.1 of a hour, point three, all of these,
What's
massive,
the point one, right?
right? Like all of these questions, and would be outlined in the retainer agreement. What disbursements, like Joe mentioned, may be applied. Also, flipping from fees, but to the relationship side as well. What might cause a breakdown in the relationship that would allow your lawyer to terminate the retainer or for you to terminate the retainer? All of those questions um, will often be answered in that retainer agreement.
And the retainer agreement is designed to save the client money. And I'm just, you talk, just listening to the last 5-10 minutes. I know lawyers who would line up at the courthouse to file their client's documents, and there'd be an hour and a half lineup. I think this is insane, right? Our retainer agreement, we're going to use couriers to serve documents or a process server. We're not doing it. That makes no sense. We're going to use a process server to file your documents at the court. We do it electronically now. Sometimes they need to be filed. That process server has 10 other things they're filing. So we're not charging you an hour and a half of our rate to line up and file your court documents. If you've ever been to court, an hour and a half might be quick. You might be there all day, or they might not accept your documents. You didn't get there early enough. So by having a third party doing it, we're saving you money. Same with experts. We're doing a lot of the collaborative work we do at our firm. We'll bring in a financial neutral to assemble the document brief with your tax returns and your financial information that the lawyers need. One person is doing it for both parties, not duplicating the documents. Some lawyers, they grind this, right? This is a economic engine for them. They want to do your financial work. They want to go through all your banker's box of records. They want to bring motions for disclosure and get on this merry-go-round where they say you produce this, you haven't produced this. That is hugely expensive. So by having us bring in a third party to do this work at a lower hourly rate than we're doing, sure, we're walking away from those fees, but we're saving you money and we're making sure the end product is done properly. So instead of Joseph spending 6 hours preparing your financial statement, you might spend an hour reviewing a draft that was done by a financial neutral. So right off the bat, you're saving 5 hours. So although the retainer agreements can look complicated and look expensive, at least ours is designed to save you money and streamline the process.
Absolutely, Russ. And what might a party or a client or somebody who's navigating the family law process expect if their matter is in court? How does that change? How does the lawyer's role change if you're in court? You mentioned, you might be lined up for hours in court. What are some things to expect?
I'm not going to do this. I'm tempted to ask Joseph because he's at court right now, day 4.
I haven't left. I'm still here.
He would know better than I would, but I've got 6 points I'm going to say, and then Joseph can tell me if I'm right or wrong. Lawyers, in my opinion, not everybody agrees with this. I think we have a duty to take on unpopular cases. It's easy to say, okay, just give me the separation agreements or the collaborative files, or I only want to work with nice people, right? That's not reality. We're dealing with people at their worst. Their spouse cheated on them, they're the victim of abuse. They might lose their home, they might lose their children, they're going to lose their identity, their friends group. Could be drug or alcohol addiction, you name it. We're getting people literally sometimes at the worst spot in their lives. And we have a chance to turn that around for them. So when I say unpopular cases, right, the person who committed the domestic assault on his spouse or her spouse has a right to counsel. The person who has child-related sex offenses has a right to have support and property figured out properly. So really your lawyer, whether you have a strong case and you're a nice person or you've made a mistake, Your lawyer is there to help you through the process. You have a constitutional right to a lawyer in this country. This is enshrined in our charter. So all the lawyers take our jobs very, very, very seriously. So you have a right to counsel. We've talked about that. You have a right to receive dispassionate, objective advice. So although I don't have a dog in the fight, that in the sense it's not my kids that are being taken away from me, I'm going to be empathetic and sympathetic towards that. But I need to give you dispassionate advice in terms of this is how you get your kids back, or this is what your spouse needs to do before we can permit unsupervised access. And you can think of a million different scenarios, but we're here to guide you through the process. We've done it. We know what the test is. We know what the legislation says. We know what the judges are expecting. And that's our job, you know. And just by way of analogy, it's like a chess game. I don't know if you've ever played chess. A lot of strategy goes on. You may need to think 6, 7, 8 moves ahead of time. Or maybe you're going to be able to solve the case or settle the case before you get to that 7th move. But you want to have a plan and a strategy in place and get you from where you are today. And when I say where you are today, I'm talking about what are your goals and interests? What do you want the outcome to look like? You know, I can tell you, I can do a rights-based analysis and tell you what I think it should be, but I'm more interested in what's important to you. I'll lay out the framework, but you tell me what's important. And then we come up with a plan to get you to your end game. Maybe that's a negotiated settlement in a very short period of time. Or maybe that's 2 years of litigation and a 2-week trial. Joseph's going through that right now. He's still at the courthouse. But we're going to develop a strategy and walk you through that. Preparation, we're going to prepare you for court. What does that mean? Well, we're going to tell you bad news ahead of time. We're going to tell you what we think the outcome is. And when usually in family law, an outcome is, you know, there's goalposts. This is a range, lots of discretion in there. The judge controls the facts. Best interests of the child could be pushed according to several factors. So we can give you a range. We can't maybe give you the exact outcome, but we can get you into the same ballpark in terms of what to expect. Preparation means serving and filing your documents on time in accordance with the family law rules, in accordance with local practice directions and procedure. That could be overwhelming for lawyers that do it every day, but for somebody who's just going through it for the first time, you know, the forms, they're going to make your head hurt. You're not going to understand all the forms and you may not get them in on time. So we're going to help with that. Preparation means getting ready for court, what to expect if you're physically attending court, what to expect if you're doing it remotely, doing test runs on Zoom like the platform we're on today to get you ready for the hearing, what the judge expects in terms of decorum. Those are the rules of the game, proper manners, how to address the court, when to show up, when it's your turn to speak. You might not get a chance to speak. Maybe only your lawyer is going to do the submissions. You might not get a chance to speak unless there's a trial of the matter, or there's an expert brought in to meet with you to discuss your parenting. So all that preparation, and then preparation for trial, and what to expect when we go to trial. How do you present your evidence? How do I address the court? How do I respond to questions that I don't like in cross-examination? We're going to go through all that. You get your decision. How do you enforce the decision? So we're going to talk about that. Maybe you want to appeal to the decision. How do you go to the Court of Appeal? What's the Court of Appeal going to do with this particular judgment? So you can see it's a long road. So preparation is key. Blind spot detection. So what are the things you're not seeing that could affect your case or cause you damage or prevent you from meeting your goals and interests? So your lawyer is going to identify blind spots, and maybe you're going to get a children's lawyer report and, you know, there's some flies in the ointment. You've got an imperfect case. We may bring in a coach to help you with the children's lawyers interviews to coach you through your answers and help you, you know, provide the best case and best parenting plan that you can. So that's the blind spot detection. How can things go wrong in your motions court or at your case conference or at your trial or your settlement negotiations? Sometimes impasse happens for the strangest reasons, and it's not the stated reason that the person's objecting to settlement. There's an underlying reason or an underlying need that's not addressed. So we work with family professionals to help understand, the very nuanced reasons why people settle and don't settle. Consequences of settlement. So you're going to make this deal. It's our job to tell you what it means, the good and the bad. If you resolve based on this settlement agreement or this court order, or this separation agreement, we need to tell you what's going to happen 3, 5, 7, 10 years down the road. How are you going to review support when you retire? How are you going to terminate child support when the kids are no longer in school? How are you going to deal with issues if assets are discovered that weren't made part of the initial disclosure package, right? Lots going on there. So we're going to talk about that. The probably the most important, trying to remember what my question was. Oh, legal proceedings. One of the most important things is peace of mind. Okay. Going to court, if you're going through a separation and a divorce, can be a very trying experience. It hangs over clients and parents' heads like a dark cloud, and that cloud's there for 1, 2, 3 years, and they can't sleep, and they're stressed, and there's eating disorders and substance abuse. There's an emotional toll that goes along with the financial toll. So by having a lawyer there to help you, to act as a buffer between you and the other lawyer, between you and your spouse, really does alleviate this peace of mind. Generally we have a fairly good sense as to what the outcome should be. And I think that's going to go a long way in terms of, getting you through this process and what the lawyer's job is when you go to court. Thank you, Steph. I don't know if Shanza or Joseph, you want to jump in there?
I think you hit the nail on the head. That's our job. We wear so many hats. Sometimes we're real estate agents, sometimes we're social workers, sometimes we're just like a support person. We wear so many hats, and our role is not just defined to the law. Which is sort of the reason why I like the job as well.
Yeah.
Every day is something new, right?
No day is the same, that's for sure. And, I think just shifting things around, because everything that we're talking about today is so connected. It's for all the reasons you just highlighted, Russ. I think that's a very strong hint or support as to why obtaining a family law lawyer for your matter is so important. We see a lot of people, self-represented litigants, so people who don't want to hire a lawyer or want to take on their matter without legal advice. And the years of experience and the nuances of the law and the process of the court proceedings, all of that you're getting in addition to tailored legal advice for you when you hire a lawyer. So a lot of the pitfalls of not having that person in your corner, that lawyer in your corner, our mistakes can happen due to the lack of experience or due to the lack of knowledge of the family law rules, of case law, of the legislation. And often it results in a lot of wasted time, wasted resources. You might have an initial hearing and then you have to bring a motion later down to correct it. And then, well, what happens if you need to appeal it? So trying to save money at the start, it may actually cost you more in the long term. So,
and I've had this happen to me. We've walked out of a case conference, and I thought, we spent 45 minutes with the judge talking about all the issues that we needed help with that day. And I thought it went fairly well. We stepped literally 2 feet outside the courtroom, and the client says, "What the hell just happened in there?" Right? She had shut down because of the stress of being in a courtroom. She couldn't remember what was just told to her 5 minutes ago. So you need that lawyer there to guide you through it, right? It could be an overwhelming experience for a lot of people.
Oh, absolutely. And, Russ, you touched on the role of lawyers in the court, but what about if your matter is not in court? How does that differ when you're just negotiating a separation agreement or a cohabitation agreement or going through mediation? How does a lawyer's role differ?
Well, 6 is my lucky number today. I had 6 points on the last one. I've got 6 points on this one. Some are going to overlap. But in court or out of court, a lot of these, apply, but out of court settlements, the role of the lawyer is to make sure your disclosure is complete. Disclosure means financial income information, asset values, all the information that affects the settlement that you're making. Now, you can make a deal with incomplete disclosure, but it's our job that you understand the consequences of that choice. Most family lawyers won't sign off on something unless we have a clear picture in terms of what we're signing off on, because we can't give you meaningful legal advice unless we know what the assets and the income are. Duress is the second point, right? If you're coming to see me in tears and your fiance is waiting for you in the parking lot and the wedding's tomorrow, and you have a domestic contract or marriage contract they want you to sign that's 12 hours off of doing your vows, obviously there's some duress there, right? And red flags are going up. So I really want to be mindful of the emotional and psychological state of my client when entering into an out-of-court settlement. Sometimes we'll be at the courthouse. Joseph's still there, might be there to 6, 7 o'clock at night, and you'll make a deal, right? Maybe you've run out of money, maybe you're tired, maybe you're close to settlement, and we sign off on the deal at 7 o'clock. Security keeps the doors open for us, and then the next day the client has buyer's remorse. That was a bad deal. They didn't want to make that settlement. They think it's unfair. They were tired. They haven't eaten. They can't think properly. They're being pressured by, the Greek chorus of extended family members or whoever is adding pressure to them. So, want to be mindful of duress, right? And the circumstances in which the out-of-court settlement is being reached. If I'm concerned about somebody's emotional state, I'll bring in a family neutral to meet with that client outside of the settlement process to ensure that they're able to instruct counsel effectively. Fairness. This is a big question, right? We're going to talk about this tomorrow. We've got another live event tomorrow about ethics in the family law. Should a lawyer sign off on an agreement that's not fair, right? Some lawyers don't want their name associated with that. The late, great Phil Epstein said he wasn't going to attach his name to an agreement. He thought it wasn't fair. Other lawyers don't care, right? You're entitled to make a bad deal, and they respect the autonomy of the person. Maybe they're making a bad deal because they want to be done with this person and they want that person out of their life. So they're going to take a bit of a haircut on the settlement just so they can move on. Or maybe they found somebody new, right? They want to start a new life with their new partner and not have the baggage of a 2-year divorce hanging over them. So they cut their losses, right? People act for different reasons, but lawyers have a duty to evaluate the fairness. If somebody's making a bad deal, that brings us to our fourth point. We have a duty to make sure that they make an informed decision, right? So we're telling them why we think it's a bad deal or what your other options are. Or like I said previously, what the consequences of these choices are going to be 1, 3, 5, 10 years down the road. And we do that based on our experience, based on our training, based on going to law school and articling and becoming a member of the Law Society. So this doesn't happen overnight, right? Or we may talk to colleagues if we're not sure. We may talk to other senior counsel or our articling principal or professor and ask them for their input on a particular legal issue. It's a great tradition that occurs in the legal profession. So it ties us into the fifth point, future considerations. We flesh that out. Sixth point I want to raise, and I always go back to goals and interests, right? Even if I'm midway through a file, like let's say we're into it for 9 months and we're going to a settlement conference, I like to pull up those notes from day one. You know, what were my client's goals and interests? Are we on the path towards obtaining those? You get sidetracked, right? Issues pop up that you don't expect. You know, there may be a change in custody. There could be a blowout with a teenage child, doesn't want to see another parent. Lots of things happen during the course of a court case or an out of court settlement, which is what we're talking about here. Maybe we need to get a voice of the child report, but I think it's always helpful to go back to day one, goals and interests. What did this client tell me was important to them? And maybe that's evolved. Maybe their goals have been updated. Maybe their interests have changed. Lots can happen. So when I have that in my mind, I think about when I'm structuring an out of court settlement for my client, enforceability. How is this going to be enforced, either against my client or for my client? So if it's against my client and there's a payment to be made, do we need to structure where there's going to be, you know, multiple lump sums over the course of time? Do we need to say we need 60 days to settle this, subject to financing being made available through the bank or a loan approval or a remortgage? So I want to think about, if I'm, you know, if my client's the one paying it, developing a practical plan and a timeline that's going to enable him or her to do that. If my client's on the receiving end, I want to think about, okay, how am I going to enforce this if the other side doesn't comply? You know, what tools are going to be available to do this? Will it be the Family Responsibility Office? Will it be, you know, a lien or security against real property? If it's something to do with children and mobility, should the passports be held? If we're worried about, you know, flight to a non-Hague country, for example. If it's something to do with the pension, I might want to confirm with the director of the pension plan that this pension can be divided in this way, if it's something unique, right? You get sort of pre-approval by the third parties that are going to affect enforcement of any particular agreement. Because ultimately, you know, you may get a court order or an out of court settlement, and then you have to go to enforce it. And then you're going to want to think about, what is a court going to require if I need to turn this into a court order? What are government agencies going to require if we need to look at the family responsibility for enforcement, for example, of support provisions? What would Canada Revenue Agency require if there's tax consequences to certain asset transfers? So we're always thinking about this as well. So a lot goes on, but those are the big ones. I'm sure there's lots I've overmissed, but you guys will fill in the blanks.
Absolutely. And I think regardless of if you are resolving your family law matter out of court or in court, your lawyer is meant to be your resource, right? If you have questions along the way, go to your lawyer. They're there in your corner. Think of, you know, I'm sure sometimes it feels like you're in a boxing match with your, you know, ex-spouse. Like, your lawyer is there in your corner to protect you and your interests, and that's their role. So
and if they don't have the answer to your question, they have the training to get the answer, right? They're very good at legal research, very good at reading legislation. So this is what we're trained to do. We do it day in, day out. I asked Shanza for an answer to a question I wasn't sure about this afternoon. She got the answer for me. So it's always happening.
Yeah, 100%. And Shanza, you know, I'm going to flip it back to you. What, you know, if we talked about the relationship and what to expect and, you know, how to go about finding a lawyer, but what happens if, you know, there's an impasse and you want to either change lawyers or just be self-represented, or, you know, what things should clients consider when sort of dealing with that question?
Yeah, so this, like you said, Steph, it ties back to what we were talking about earlier, and all the tips that Joe, you mentioned. Clients look at all those to see if the lawyer is a good fit for them, right? And if they don't feel comfortable with the lawyer, they don't think that this lawyer can represent them in court or outside of court, um, then you can always get a second opinion. Or if it comes down to it, switch to a different lawyer. There's a number of things that you want to consider. I don't know if I have a 6-point list like Russ, but I will go into some considerations that you can consider.
I just want to tell you why I do that. Judges hate when lawyers go on, right? We all hear lawyers. They talk, they have no idea what they're talking about after 30 minutes, right? Everybody's gone to sleep. So I do that as a tool to keep judges engaged. If I tell them I've got 5 or 6 or 7 points, I usually know how long it's going to be too. And then the judge goes, okay, I got 2 more points left, right? I'm be done with this Alexander guy. It's just a good way to keep your audience on cue. But go ahead, sorry to interrupt.
No, that's a great tip. Thanks, Russ. That's something I can use too in the future. So thank you.
Joseph's going to use it tomorrow.
All right. So in terms of switching lawyers, back to the topic we were talking about, you want to make a conscious decision because it can be costly, right? You will have to pay your first lawyer to copy your file for your new lawyer. You'll have to pay the new lawyer to read your entire file, get up to speed. You'll have to pay their retainer. So overall, it can be a costly decision. So you do want to make sure that this is what you want. And some of the things that you can consider are, first, you want to know the reason why you want to switch, right? Is it a matter of personality conflict maybe, or are you dissatisfied with your lawyer? Do you feel like, they're not responsive enough, or are they not advocating for your interest effectively? It's crucial to really identify the specific issues that you're facing with your lawyer to know if a change is necessary. If it's something like, for example, they don't answer your phone calls or emails quickly enough, the communication is kind of not up to the standard that you prefer, you're not satisfied with that, I think the first thing that you want to do is bring it up with your lawyer. Right? They might give you a satisfactory answer. As Joe said, that they can give you some insight into, why maybe sending email every day is maybe not the best idea, or it could essentially, it is in your favor that you would be saving costs and money in terms of, do you really need to send that email? Well, depending on the timeline of your case, maybe it's all right, maybe you don't need to communicate with your lawyer that often, but again, like, you want to talk the problem out. It could be a number of reasons why the communication is not up to par, or what are some of the possible solutions. Maybe you just need to communicate to your lawyer what your expectations are. It could be just their working style. There are also instances when where you are not frustrated with your lawyer per se, but more so it's the legal process, it's the court process in general that you're frustrated, that's causing all the frustration. You might end up changing lawyers only to encounter the same difficulties with the next one, right? The next lawyer might say the same thing. The law can't change. If you are not getting a satisfactory answer from your lawyer, it could just be that the circumstances don't allow for a more favorable outcome. All right, we talked about this earlier today. You want to get the bad news from your lawyer, not from the judge or the opposing counsel. There's no point, like, you don't want assurances and promises when it's likely that your position is maybe weak or it's uncertain. Like, we don't know what way the case could go. Changing lawyers can also slow your case down because you may need to adjourn your upcoming court date. Your lawyer may need time to get up to speed with your file. Court dates can be really far apart, so there can be significant delays when it comes to that. On the other hand, it could be that your lawyer is not a good fit, and every lawyer has their own personality, their own advocacy style, their own take at things. Some lawyers are more experienced than others in certain areas. So maybe switching lawyers is the right answer for you. If you're not sure, I think you want to start by getting a second opinion, and that can guide you in terms of what your next steps could be.
Yeah. This is such a tough choice for a client, right? It's ultimately the client's choice. It goes down to trust. Can I communicate with this lawyer? Can I trust their advice? Shanza, you're right. And I tell this to clients, there's a cost to switching horses halfway through your race, right? You want to bring me on, I got to read the file because I need to know all the work the other lawyer's done. Because I could be asked by the court or in trial about a specific document. So might be 3-4 hours of time for us to get up to speed, depending on how complicated your case is. But there's something, you don't want to make a deal and then think, okay, that lawyer screwed me, didn't represent me properly, excuse my language. Maybe it's time for a fresh look, or maybe it's time to go get independent legal advice. So before you change your lawyer, go have a meeting with another lawyer. That lawyer may say, yeah, your first lawyer's right on track with doing a great job. Or they may come up with a different outcome that your first lawyer may have overlooked. So independent legal advice is always an option before you switch out lawyers. But I gotta say, and I love our audiences and send in your questions, but if you're going through 3, 4, 5 lawyers, that's a red flag when you go see a new lawyer. If I see somebody coming in and they've already been through 5 lawyers, I'm gonna be concerned, right? I'm gonna be thinking maybe that client is not following their lawyer's advice, or has misled the court, or has misled that lawyer. So, I started off by saying everybody has a right to counsel, even unpopular clients, but you may find it as you progress through lawyers a little bit more difficult to have lawyers take on your case. There'll be lawyers who'll help you through it. We're here to help you through the process. But that's not only the lawyer's lens. I think you'll see that not overtly, but very nuanced from the court. And because when I've taken over a file where there's been 3 or 4 other lawyers involved before me, the first thing opposing counsel says almost always, oh, Mr. Alexander's lawyer number 4 in this case, right? Which is a cue to the judge saying, my client's the one acting reasonably. They're the ones firing their lawyers or delaying the process. So it's a bit of a slippery slope that way. Certainly a fresh look coming, sometimes lawyers burn out, right? After 3 years of litigation, maybe it's time to get a new lawyer involved in the case, or the lawyer can't do it anymore. They're stressed out, or they've got other issues, family issues that they need to address and take some time off of practice, or maybe they're going on a mat leave and they can't help your case. So there's lots of reasons, legitimate and not so legitimate reasons to change lawyers, but you want to be mindful that lawyers have pressures on them. They have family and mat leaves and other commitments, and you may not have a choice but to change lawyers. But really important topic, Shanza. Great work covering it off.
Yeah, 100%. And I think the tip that you mentioned, Shanza, too, about just speaking to your lawyer and it's talking through your relationship, understanding where the pain points are. Maybe you need to reevaluate what the expectations are. If you're expecting an answer in less than 2 hours, or immediately after sending an email, and that lawyer is like Joseph's still in court at 6:15, just remember that your lawyer is human too. I'm sure if you just bring it up with them, they'll be able to talk through and work out whether you have a plan moving forward, or maybe your relationship, your personalities just don't click, and it's not to the fault of the lawyer, not to the fault of the client. It's just you need to readjust and find perhaps a better match for what you are searching for your representation. So speaking of finding lawyers and support. And, you know, Joe, you touched on it a little bit, but before we just quickly wrap up, do you want to touch on legal aid and for those clients who maybe need assistance or some financial resources?
Yeah, for sure. So, obviously, some people, most people, few people are not in a position to hire an attorney, given their social economic status and, you know, the things that they're going through. And so the government, as well as a lot of different public/private entities, help provide resources for those who are not fortunate enough to be able to hire a lawyer. I'm just going to list off a few different ways in which people can obtain legal advice, either at a less of a cost or no cost at all. The first being Legal Aid Ontario, short form for LAO. Legal aid provides eligible individuals with subsidized legal representation for family law matters. There's also duty counsel services. So duty counsel lawyers offer free legal advice and representation to individuals who do qualify at courthouses across Ontario. There are also family law information centers. We call them FLICs. So FLICs provide information and resources for individuals who are navigating family law issues, including guidance on accessing legal aid. There's also community legal clinics. So some community legal clinics offer assistance with family law matters to lower income individuals. There are also pro bono services. So some lawyers and legal organizations offer pro bono services. Pro bono just means free of charge. And they offer services for family law cases on a voluntary basis. Our firm, Russell Alexander, we actually do that twice a year. It's a really great initiative to provide back to the community. There are also mediation and alternative dispute resolutions, also known as ADR. Really important too, if you're looking to save some money on court fees or legal fees in general, to consider alternative dispute resolution methods, which is more often than not a more cost-effective method than traditional litigation. Sorry, excuse me, it's been a long day. And also referral services. So legal aid referral services can connect individuals with lawyers who offer reduced rates or payment plans based on their financial need. Also can refer them to lawyers who do accept legal aid certificates. There's also public legal education. So it's really important for people to take advantage of public legal education resources to better understand their rights and options in family law cases. There are a lot of libraries that offer these on the internet, a lot of really great resources. And finally, financial assistance programs. So there are government programs that provide financial support for legal expenses in certain situations. Some situations could be for victims who people who are victims of domestic violence. There are also subsidies for that. So there are a lot of really, really great resources for those that may not have sort of a treasure chest that they can go to.
And that concludes today. It's been a great topic, definitely a more personal one, less substantive in the sense of legal matters or topics, but questions that we get a lot as people are searching for lawyers and looking on how to start their case.
Steph, amazing job hosting. You make it so seamless. Shanza, Joseph, fantastic. Joseph, you might as well just sleep there because you're gonna be there in like 6 hours, right? What time you start tomorrow morning?
We have a 10 o'clock start time, but get here a little bit early. No more cross-examination of our client, which means we can talk to her. So we might be here a little bit early and just going over some stuff.
Great. Have a great night, everybody. Thank you so much for joining us for this after hours. We'll see everybody next week.
Bye, everyone.
Bye, everyone.